Your Honor. My name is Annie Choi, and I represent the people of the state of California. The people respectfully request you deny the defense motion and permit the admission of the incriminating items in the defendant Ray Concha's car as seen in plain view by Officer Doran.
Let me ask you something, Ms. Choi. What would happen to your case should I grant the motion? Would you still be able to prosecute?
Yes, Your Honor. If you grant the motion into the case, then my co-counsels will be able to show how the defendant was in possession of the drugs prior to the second search.
So you don't really need this evidence. Can't I just take the easy route and exclude it if it's not going to impact your ability to prosecute?
Well, the evidence today helps to establish that the defendant had a pattern of participating in the incriminating activities.
Okay. Let me ask you also, I know you have to prove this case beyond a reasonable doubt. Do I have to find that there was a Fourth Amendment violation beyond a reasonable doubt, or what kind of standard should I be using when I look at this question?
Can you repeat the question?
All right, so do I have to find, in order to grant this motion, to exclude that there was a Fourth Amendment violation beyond a reasonable doubt? Or that there wasn't a Fourth Amendment violation beyond a reasonable doubt?
There was not a Fourth Amendment violation beyond a reasonable doubt.
Well, what I'm asking you is that the standard that I should be using when I look at this question?
Yes.
Go on.
A roll of money, an accounting list, and a bag of orange-colored pills. Those items were in plain view in the defendant Ray Concha's car when they were observed by Officer Doran on the night of Friday, February 27th.
Now, wait a minute. You say plain view, but we just heard from the defendant that the officer needed to actually climb up on the car in order to see everything that was in the car?
Yes, Your Honor, but however, stepping onto the passenger tire of the car still puts what the officer observed in plain view. As seen in the court case Texas versus Brown, the officer...
What part of the Brown case should I be looking at to say that, does Brown make any finding that it's okay to climb on somebody else's property for it to be plain view?
The ruling of Brown does not explicitly state that climbing up still constitutes plain view. However, in a similar principle, Texas versus Brown establishes that bending down is...
Yeah, but this isn't bending down. That's a natural movement. This requires going onto somebody else's property.
A car has lowered expectation of privacy then.
Well, we'll get to that in a second. But do you recognize any difference between just naturally bending down and having to climb up on somebody else's car in terms of whether an object is in plain view?
Your Honor, it's still in plain view because both positions of bending down and stepping up help the officer, and it aids the officer in allowing to get a clear view.
Let me ask you this. Let's say you're in a restroom, right? And the doors on the stall of the restroom don't go all the way up to the ceiling. Like most of the times they go up maybe 3/4 of the way. Are you telling me that if there was an officer who was perched on top of, let's say, a cabinet and was able to see down into a restroom stall, that should be plain view? Don't I have to consider the vantage point of the officer and whether it was a natural vantage point or not in order to assess whether it was in plain view?
Your Honor, similarly to the situation you gave, vantage point is important when analyzing plain view because a tall person might have had the exact same vantage point as Officer Doherty when she had to step onto the hood of the car. So taking that into account, we cannot define plain view by what the officer had to do in order to see the interior of the car.
So if an officer was tall enough that they can peer over a restroom stall, that would be okay with you?
Yes.
Now, let me also ask you, they were relying on Horton. What's your position on whether or not Horton should govern this case?
All three of these these principles were met in our court case today. In Horton, it says that an officer must be lawfully present, and in our case, the officer was in a legal position when she looked into the interior of the car.
Did the officer have permission to get on the defendant's car, to peer into it? Didn't he trespass onto the car?
It might have been an unwelcome gesture to step onto the passenger tire of the car. However, a car is not the same as a home, where you need permission to step onto perhaps the front porch of a home.
So anybody can just walk on your car? Don't you have some type of property interest in your car that would prohibit strangers from walking on the hood?
There is some degree of expectation that people will not step onto your front passenger tire of the car. However,
But he was
that,
also on the hood of the car, is my understanding.
Yes.
Looking through the front of the windshield.
yes, but this expectation that somebody will not go onto the front of your car does not rise to the level of the Fourth Amendment protection.
Well, what I'm asking is focusing on Horton, on the first prong. Don't you lose if I find that the officer wasn't lawfully present when he was on the hood of the defendant's car?
When the officer stepped onto the hood of the car, what the officer observed was still in plain view, and therefore it does not qualify as a search where the officer needs to have a warrant and
But don't you need to be lawfully present before we even get to plain view?
yes, Your Honor. Since the officer stepping onto the car is not the defendant's private property. It is the defendant's belongings. However, it may be a trespass, but it is not a violation. May I proceed?
Yes.
Because these items were in plain view, there was no violation of the defendant's Fourth Amendment rights.
Again, you said plain view. The defense made mention of the fact that there was tinting of the windows and that the property was covered. This was during the day or during the night?
During the night.
During the night. And were the windows in fact tinted?
Yes, Your Honor.
You couldn't naturally see into that car, could you?
A tint only provides a tint. A tint does not block a person's visibility into the interior of the car.
But you couldn't see it naturally at night with tinted windows, right? Isn't that what we need to be concerned with is whether there was an expectation of privacy? So if I were to find that putting an object in a car at night with tinted windows when no person could see into it was consistent with having a reasonable expectation of privacy, would that end the issue?
Your Honor, the defendant indicated the lowered expectation of privacy when she parked her car in a public parking lot with a partially open window. Those were indicators that the defendant had a lowered expectation of privacy.
Were the doors locked or were the doors open?
I do not know if they specify that. May I proceed, Your Honor?
Yes.
The defense argued that Officer Doherty violated the defendant's Fourth Amendment rights by looking into the interior of the car. However, the Fourth Amendment explicitly states that all persons have the right to be secure only in their persons, houses, papers, and effects against unreasonable searches and seizures. Not in an open field, not in a workplace, and not in a car.
Why not in a car? Do you have authority for that proposition?
Your Honor, in a car, the clear windows allow for any passerby to look into the...
But this wasn't clear windows, these were tinted windows.
A tint only provides...
This was at night with tinted windows. So do you have, what authority should I look at for the proposition that a car has somehow lower expectations of privacy?
The tint only provided a minimal barrier to the visibility. It did not
But do you
completely...
have authority? What case should I look at that would let me know that there is a lower expectation of privacy in a car?
Well, similar to US versus Copland, an airplane is a mode of transportation like a car.
But
And
in the Copland case, right, there was a specific finding that in an airplane, you can shut the shade to block public view, and there it wasn't whole. But here, there is no mechanism by which to cut off public view, but tinting of the windows. Isn't this case like the Copland case, except with the tinting of the windows being the missing fact in that case, where the windows were left open to public view as opposed to closing them off to the public?
Your Honor, we must consider that the defendant left her back window partially open, thus indicating the lower expectation.
What do you think a person can do in their car when they want to keep the contents of that car private that this defendant failed to do?
The defendant had the opportunity to place the incriminating items in perhaps the trunk or in somewhere that would not be in plain view.
First of all, is it even conceded that these were the defendant's items?
I'm not aware of that. I don't know about that.
Is the defendant disputing whether or not these were their items?
Well, this would show if we permit the admission of this motion, then it would show that the items found in the future, in the search in the future, that these did belong to the defendant because the defendant had these items prior to the second search.
Another thing that the defendant had mentioned was that the objects weren't in plain view because the officer actually needed to shine a flashlight into the car in order to be able to see them. Shouldn't I find that using this type of device to aid one's natural senses is itself a constitutional violation?
Your Honor, a flashlight only helps in allowing the officer see the items already in plain view. And similar to the case People versus Rogers, the officer in that case used the flashlight to see the interior of the vehicle.
Right, and they were arguing Kylo, so what's your response to whether this case should be governed by Kylo?
Your Honor, this case is different from Kylo in that the thermal imaging device granted the officer vision of what was not priorly available.
But isn't that like a flashlight? The flashlight was enabled him to see something that wasn't otherwise available.
However, if this search happened during daytime, that vision would have been granted to Officer Dory.
No, but there was tinted windows. It's not so clear that he would have been able to see the contents of the back seat through his natural vision in the daylight. So isn't this case really more like Kylo, where it was enabled somebody to accomplish something that was humanly impossible otherwise? Do you have any authorities that I should look at in examining the propriety of using the flashlight?
Well, if we follow Kylo versus US and we use the principle established in that, this case is dealing with the expectation of privacy in a home. However, a car is different.
Well, we have people who live in their cars, don't we?
Yes, but our court case is not dealing with a mobile home.
Well, but even regular cars that aren't mobile homes. So sometimes people who are homeless have cars and they end up living in their car. Can't we have circumstances where a car is the equivalent of somebody's personal home? I mean, you seem to suggest that cars are fundamentally different from homes across the board in all cases. But would you acknowledge that there can be situations where a person is residing